is May and Jay's video about the zero breeze able to be used just because Thunderfoot is criticizing Zero Breeze? Shouldn't he stick to using Zero Breeze's footage, authorized footage from Zero Breeze or something? Well, no, because he really was talking about and criticizing not just Zero Breeze, but he was commenting on May and Jay's use of the Zero Breeze and experience with the Zero Breeze and what they were saying. So it wasn't, it doesn't just that he wasn't just criticizing Zero Breeze, he was also commenting on their use of the Zero Breeze.
This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
First, I thought we would talk about the Thunderfoot takedown that was issued by May and Jay. I don't know. Andrew says it's May and Jay. So there was the Zero Breeze debunking that Thunderfoot did. If you don't know who Thunderfoot is, he is I don't know if he's British born or just has an accent or what, but I think he's from the States. I don't remember if he lives in the UK now or not. He definitely has a British accent. And he does debunking of things. So especially things that have to do with water and very basic principles of thermodynamics. For instance, energy cannot be created and destroyed. It can only change states. If you increase the energy in a system, it either has to escape or it stays contained in the system. So very simple things he's debunked, like some of the water bottle ones where they claim that if you just add a battery and some circuitry to a water bottle, you can miraculously extract water from the air. And yeah, it's physically possible to do so, but extremely inefficient and somewhat dangerous because you have that same risk of mold as we just talked about with the Fallout 76 thing. So Thunderfoot makes these debunking videos, and he definitely makes fair uses, and that's what this is about. Is it really a fair use when he shows Zero Breeze's video, or in this case, May and Jay's the Zero Breeze video about their experience with the Zero Breeze, and then he goes on to laugh and point and make fun of the lack of science involved in the thing and how inefficient it is compared to a compressor-based air conditioner, and how better technologies exist, and in his opinion, how the whole thing is a giant scam or sham on some level. I don't think he's saying or ever says that the devices don't work at all. I don't think we even really think that matters to the copyright analysis. Maybe it matters to a defamation analysis or something, but I think he mostly just uses their video and makes commentary or criticism on top of it, which is more or less exactly what fair use was made to protect. So I watched these videos because I happened to have downloaded the videos before I got on a plane, and then managed to watch the video on a plane before it got taken down. And maybe even if it had been taken down, as long as my phone didn't reconnect to YouTube, I think it would have been able to keep playing. So I did watch the video about Zero Breeze, and I do remember the segment where he used, at least I think it was May and Jay's, or whatever her name is, video in his debunking video. And so then to hear that he got a copyright strike, a DMCA takedown notice for having used a portion of their video is amusing. It's amusing to me because I can watch from afar and not have to be worried about my client's, situation or how I have to respond to it. I did reach out to Thunderfoot and offered to represent or at least advise if necessary, but I'm pretty sure that he has his own lawyer. There was a video he put out that said that he was prepared to make legal demands or legal threats or something. I'm not sure if he actually did that through a lawyer, but it sounded truthy, so maybe he did do that through a lawyer. So I just wanted to talk for a second about fair use. I mean, we have the H3H3 case, which is now basically precedential in the Second Circuit, and a good idea for anyone outside the Second Circuit to follow. It's very persuasive. And it went over basically these same facts and basically the same situation And the question really becomes, in this case, was there enough material used that it somehow becomes not a fair use? Or was the fair use rule or law followed? The point was, or at least the point of fair use, is to protect that criticism and commentary. When you are adding something to, and this is not something where any argument wins in either direction. So it's not a matter of, well, Leonard French here is a human being, and Leonard French can come up with any rationale. No, this isn't that kind of test. This is a balancing test, and it's balanced against actual legal standards that are quite well defined and hardly ever have to get to a jury, because we usually are able to whittle these things down to a particular type of use or situation, and we're able to settle or otherwise dispose of the case on summary judgment, and those things eliminate a jury trial, which you don't really get to a jury trial too often. And even then, most of the time the parties agree that jury trials are expensive even for the parties, who have to go through this extra jury selection process. So a lot of times we have a bench trial on copyright issues just because of convenience of the parties, but certainly possible for anybody to ask for a jury trial. So the jury would eventually, or the judge would eventually or inevitably have to rule on the 4 fair use factors and whether they were followed. And the first fair use factor is that purpose and character of the use. Is it transformative in nature? Is it criticism, commentary? Does it add something, or does it merely copy? And so definitely 100% Thunderfoot's video was criticism and commentary about the Zero Breeze. Was it criticism and commentary about May and Jay's Zero Breeze video? Well, yeah, but this is an important distinction to be made here. If you have a video like May and Jay are making a video about Zero Breeze, and they have permission to make the video and everything, and it doesn't really matter whether they had permission from Zero Breeze, but you'll see what I'm getting at in a moment. If Thunderfoot makes a video about Zero Breeze, can he just go and use anybody's video who has happened to review a Zero Breeze? That's probably the legal issue at stake here. But let's return to that, because that might be the thing. The second one is the nature of the copyrighted work, commercial or not commercial, educational, not educational. May and Jay's is commercial, Thunderfoot's is commercial. Maybe there's an educational aspect to Thunderfoot's use, but let's just stick with the fact that they're both commercial, and that sort of doesn't really inform our fair use analysis. The third factor is the amount and substantiality of the portion used. Did Thunderfoot use only enough of May and Jay's video to make the criticism and commentary point, or did he copy so much of the video that there's just way more copied than you would ever need to make the criticism or commentary point? And I don't think that there's any problem here for Thunderfoot. I think he's copied only the part that he needs. The video of May, or I think it was Jay actually, using the thing inside of his truck and taking various measurements, and Thunderfoot is talking about whether or not this device is efficient or not. And then finally, the market usurpation factor. This is a big one. This isn't dispositive. It's a balancing test, and no one factor weighs more than the other. It's how the facts fall on the factors. It's what you put on the scale that determines whether a factor is dispositive or not the factor itself. But this one's pretty big. If you watched Thunderfoot's video, would you not have to watch May and Jay's video? If you wanted to watch May and Jay's video for its content, but you saw Thunderfoot's video first, would you, not because of his criticism, but rather because he showed you their video, would you have seen enough of their video that you don't need to see anything else? You got the heart of their video, and and no longer have to go and watch it. So think of like Mystery Science Theater 3000. This is Mystery Science Theater is not a pure example because they had permission. KTLA had given permission. They had permit, or they had gotten permission to use all the material that they had. But you have these actors sitting in front of a screen and making constant commentary and jokes over top of something. That's market usurpation. Just because they transformed it into something new, just because it could have been a fair use, because they're doing criticism and commentary, that does not change the fact that you could watch the entire movie from start to finish on Mystery Science Theater 3000. So I don't think that Thunderfoot had a market usurping in the fair use sense, a market usurping function. Criticism is allowed to diminish the demand for something if the criticism, if the public determines a criticism at their own determination, not the court has to agree or anybody has to agree, but if the public decides, if the viewers decide that, oh yeah, well, after hearing about the criticism, I decide I don't want to watch something because the criticism was that it's just not good, or it's not worth watching or something. Well, that's one thing. If you don't have to watch it because you already saw it, that's another thing. And I don't think Thunderfoot is in any danger there. Where I think this came close to not being a fair use is where I said before, is May and Jay's video about the Zero Breeze able to be used just because Thunderfoot is criticizing Zero Breeze? Shouldn't he stick to using Zero Breeze's footage, authorized footage from Zero Breeze or something? Well, no, because he really was talking about and criticizing not just Zero Breeze, but he was commenting on May and Jay's use of the Zero Breeze and experience with the Zero Breeze and what they were saying. So it wasn't, it doesn't just that he wasn't just criticizing Zero Breeze, he was also commenting on their use of the Zero Breeze. So I think he's firmly on the side of fair use. I would defend it in a court of law, but I would definitely tell my client that there were risks here, that if that use wasn't commentary on May and Jay's video, if it wasn't as clear, probably not a fair use. What was another? There was an example where we came up with this earlier when we were talking about the Area 51 case. We had used a few minutes of the jailhouse interview, and I was uncomfortable with that because although we were commenting on the situation involving the Dutch men who were arrested at Area 51, I was commenting directly on their incarceration, not on the TV stations. I think it was KTNV, not on the TV station's video. I was using their video, but I wasn't commenting on their video. I wasn't saying something like, oh, look at the way they made this camera angle and how they were able to get this shot figured out this way, and the director would have had to have, or the producer would have. None of that. I was talking about the contents of the interview, the actual interview itself. That very much may have been copyrighted material. So I was much less inclined to consider it a fair use without using almost nothing of it, just a few seconds here and there. I felt much more comfortable. Certainly, people could disagree. Like I think reasonable people can disagree on what fair use is in that context or not. Brandon, for example, he disagreed at the time. I don't know if he still disagrees or not. Go ahead.
I still disagree. I mean, if we go through the factors of fair use, the question is, what's the amount of substantiality of the video that we used, right? I know you already went through one of the factors, and that's fine. But we only used a small portion of the interview. I don't think we usurped the market for the interview, because if somebody wants to know what the rest of that interview said, they have to go watch it. All we did was comment legally on your opinion on the on whether or not he should have done that, which, I mean,
well, are we talking about the final edit or the initial edit where much more of the interview was included?
I'm talking about the initial edit, my edit.
Okay.
I thought I did a good job of cutting out stuff that wasn't relevant. But I don't know, maybe not. I'm not a lawyer. And I think that that's a question that should be answered, because I feel like the content of the video is a part of the intellectual property.
Yeah.
The same intellectual property. and so it's protected the same way, which means that we would be able to use it as long as we didn't.
Well, with the TV station, their argument, if they were to say it's not a fair use, they would come after it and say that we had usurped the market because they're in the market of shooting interviews, and then anyone who wants to use the exclusive interview footage can call the news desk and get a license for it. So I'm not commenting and criticizing on the TV station's obtaining of an interview or licensing an interview. Instead, I'm commenting on the interview. I think it's a little bit less clear because the TV station isn't the generator of the content. They didn't write the news. They didn't say, here's we're going to make two Dutch people do this and then we'll have a news story. No, it happened and then they reported on it. So it's a little bit different in there. The copyrighted content would be the interview, would be the footage, the video of the interview.
Yeah, I think of it as like you got to be a little meta where you can't use the video for its original intended purpose. So the original intended purpose was to show an interview with these guys. And that's why we were showing it too, which usurps the market. And so it's not transformative in and of itself, even though we're providing commentary that didn't exist in the original video. But if we had done something meta where we talked about, what questions the interviewer asked, or more like, again, as Leonard said, with like camera angles and stuff, now we are commenting on the video itself for a different purpose than what the video originally was for. Does that make sense?
Yeah, that's also a good explanation. The purpose is a different purpose. So Thunderfoot's purpose is to criticize Zero Breeze and really anyone who's defending it and comment on anyone who's using it, whereas our purpose is to comment on Area 51, for example, and the situation there. But the purpose of the news report or the interview was the same thing. So we're doing the same thing using their material, and we needed to make sure that we were firmly on the side of fair use. What do you guys think of the Thunderfoot situation? I think it's a fair use, and the claim is bogus, and I'm glad to hear the claim was released, and I think that's the end of it from there. The parties have made respective videos about how they're so unhappy with the whole thing. Thunderfoot's claiming victory, and May and Jay is claiming that they did nothing wrong. So certainly there's no need to go in and really harass either party. This is just a discussion, but what do you think? Let me know in our comments. So thank you for joining me. I am Leonard French, your favorite copyright attorney. Thank you for supporting our channel with your views and literally your financial support. This channel would not be possible without your financial support. We are continuing to get demonetized here and there regularly by YouTube, including on Wednesday's video about Chuck Yeager, which made absolutely no sense to us. Our revenue is down 25% or so, even though our views and subs are up 10% or more. So it's very frustrating to deal with YouTube. They say things are going to be fixed sometime soon, but they've been saying that for 2 or 3 years now. So who knows? Thank you for your support on patreon.com/ljfrench and sponsors.com/law. And thank you especially to our supporters and sponsors in the month of September. Thank you to our channel sponsor, Joshua Davis from TandaPay. We're working on a longer video or even videos about TandaPay, which is kind of a cool way that communities can insure themselves for problems that community foresees. For example, maybe there could be a Tanda or TandaPay, we're trying to work on the terminology there, for people who receive false DMCA claims. And not in the sense that we would then crowdfund, but rather people who were susceptible to false DMCA claims may all, like YouTubers Union, may all put a small amount of money into a monthly Tanda, and then if someone gets hit, then that can pay out to the people who get hit in the form of hiring a legal defense for them. We're talking about this. It's a strange concept, but we think it's actually a very powerful and positive concept and medium for change. So thank you very much to Joshua Davis and TandaPay for sponsoring us in the month of September. And thank you to our $50 plus supporters, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Michael Pearce, Spirit Bear, Jan Negrey, Daniel Perez, Snorre Wisotzky, Joe Tyson, and Blackleaf. Thank you all very much for your support. And thank you to the $5 plus supporters scrolling on the LED panel behind me. And everyone will be in the crawl of the video at the end of the videos. So that's our show for today. Love you all. Have a great Wednesday, a great week. We'll see you in the videos that drop. Thank you for your support. I'm Leonard French, your favorite copyright attorney. Have a great one. Bye.